course, I tend to be leading this a little bit, but we know that personal injury has negative connotation, and this is the opportunity to share appropriate and objective information. I understand that many people, when they have some sort of injury, they may go to a doctor or a hospital, and it may be a short-term problem that is solved. But I also understand that there's sometimes an issue about waiting too long before you make a determination about whether or not to go to a lawyer. How does someone decide when to see you, or if to see, when to see you? First hospital visit?
Well, certainly if it's a major injury, then of course you want to see an attorney. If it's due to somebody else's negligence, you want to make sure that the wrong is righted, so to speak. It's always best to look at, to always go to an attorney. What's the cliche about representing yourself? But again, we do find that some people do want to represent themselves, but we have resources to us that an individual may not have. For instance, somebody gets a serious injury, very serious, may debilitate them for a long time, take them out of work. We have people that we can send, for instance, experts, like somebody to do a life plan to determine how long this injury is going to, how long it's going to affect this individual's life, what kind of life are they going to lead. We have those resources.
How much it's going to cost to care for them for the rest of their life. It's very important, as Jackie says, that if you have a catastrophic injury, that you think about not just what you need now, but what are you going to need in the future. And those are some experts that we have that we would turn to. And then you have to take that cost into the future and reduce it to a present value. That's another expert, an economist. Then you could have the lost future earnings that you never can work again. What's that worth? Again, an economist needs to figure that out for you. That's one aspect of it. And the other aspect that Jackie was alluding to is experts. You might need an accident reconstructionist to determine how the accident happened and whose fault it was. It's not always so easily, it's not that someone stopped at a red light and gets rear-ended every time that an accident happens, or if it's a slip and fall, what caused the slip and fall. We have experts that we can use to determine who is responsible and whether or not there's negligence on part of the defendant.
The other thing, too, is I think individuals themselves, laypersons, they may not have any understanding of how to value a personal injury case. We use something similar to a formula. It's not a golden rule, but how do you value a case? And they might just think whatever the insurance company may offer them, that's it. You know, that's what it's worth, that's what they're accepting. And that's where we come in and we say, well, no, wait a minute. The insurance company's in business to save you money.
Save them money.
To save them money. But here we are, we're in business to evaluate the case. We're in business to represent your interests. Is the insurance company representing your best interest?
And it's to make sure that the maximum that you should receive is recovered. What happens a lot of time in these cases is an insurance company, if they have someone who's unrepresented, will make a very low-ball offer. And they'll say, well, if you hire an attorney, and we're going to talk about this a little bit, they're going to take a third. That's how they get paid. And we're going to talk about what that's all about. But what they're trying to do is scare you into just accepting the money because they're going to tell you that you're going to have to pay the attorney a fee and you don't want to have to do that. And when I've had cases where people have come to me for scarring, for example, where the insurance company offered him $10,000. This is a lot of money. If you go to an attorney, you're going to get less because you're going to have to pay him a fee. And we ended up settling on the case for $50,000. So after our fee, they had much, much more than they would have had on their own. And the other thing we do is we have access to all the cases we've handled, so we know what cases are worth from our own experience, but we also have access to a database of every case that's tried to a verdict in the country, so we can go and say, all right, we've had this injury, this injury, this injury. What has that been worth at trials before? Because the long and short of it is the value of a case is really dependent on what you could get at trial. You want to avoid trial, and I was teaching a class last night at Johnson & Wales to my business law students, and I told them the best case is a settled case. If you can avoid litigation, you want to avoid litigation, but you have to have the ability to go to court if you need to get what you're entitled to.
What's the actual process if something happens and you've been to a doctor or a hospital, as we've said, but we're able to move out of the hospital, we can be at home. We pick up the phone and call you. What's the first thing that happens? What's the process?
The case will start with an interview.
An interview, free consultation, and again, we would explain what our services are. If they decide to hire us at that point, we have an obligation, excuse me, to go over what our fee structure is, to make sure that they have a signed fee agreement. We would tell them what our plans are with regard to the case. Certainly, we would give them advice as to whatever treatment they may deem necessary. Always listen to your physician. Make sure you follow up with your physician's requests. Make sure you follow up with physical therapy. That we open a case. Essentially, we open a case. We open a file. We send a letter of representation to the insurance company. Once the insurance company gets a letter of representation from an attorney, they are prohibited from any further communications with the individual.
And what we're trying to do at that initial interview is get as much information from our client as we can, so we make sure that we can bring in experts early if we need them, if it's an issue of liability, if it's an issue of medical care and they don't have doctors, we will give them names of people we think are good and can help them. We want to make sure that they are being taken care of first and foremost for the injury. And then as the case progresses, we'll keep informed by email or telephone with our clients to make sure that we know what's going on with the case. And the first question we get sometimes is, when can my case settle?
Yeah.
And we tell them,
How much am I going to get?
how much am I going to get and when can it settle?
Typical.
Well,
Yeah.
that we can't answer until we see what your treatment is. And I will also tell them that you do not even want to think about settling a case until you've recovered. If it's a situation where you're not going to have a permanent injury and you're going to recover, let's wait till you recover. Because at the end of the day, when you do reach an agreement with the insurance company, you sign a release. And what I tell my clients when they come in to sign the release is, among other things, this is saying that you can never go back to the insurance company and ask for more money, even if you find something was injured in the accident that you didn't know about before you sign the release. Once it's done, it's done. So we say, let the doctor, the physical therapist, whoever it is that's giving you medical treatment, tell us, when you're done.
That's what I was going to point out. We rely on the information we receive from their physicians. We can't tell them when to stop treating. That's not our job. We're not doctors.
Right.
We're lawyers, I guess.
Yeah.
But in any event, we rely on their treatment notes, their expertise. When we get a release from a doctor, we make sure that we get a written discharge, and as part of our obligation is we get copies of all of their medical records. So they sign releases when they come in to meet with us for medical records, for lost wages if they work. But again, we have to rely totally upon the physician's recommendation, and if the physician makes a determination that the person has reached a maximum medical improvement, then we get a letter of discharge from the physician, and then we're in a position to evaluate the case, determine how many weeks of treatment, put a value on the case, and then send out a formal written demand to the insurance company requesting a number, so to speak.
Jackie also had mentioned a written retainer agreement. A contingency fee agreement has to be in writing, and you want to know.
That's what I was going to ask you
Yes.
about. Please elaborate on that.
You want to know exactly what your responsibilities are, what you're going to pay. And there's usually 3 or 4 different ways an attorney can charge fees. It could be a flat fee for a service that's going to be provided, if it's a will that you're drafting or something like that. Family court, we often charge a retainer against an hourly fee, so we bill hourly for that. Contingent fee agreement is basically exactly what it says. Our fee is contingent upon what we receive. So if we go through the whole case, we go to trial, and the offer at the end of the day or the jury award is 0, we get 0 for our fee. We take the risk. An attorney will therefore really carefully evaluate a case before he accepts it to make sure that he's not wasting your time or his time. So in the agreement, it'll talk about the fee, which is generally, some attorneys will charge 1/3 if it's settled, 40% if it goes to trial, and more if it goes on appeal to the Supreme Court. The other aspect of the fee agreement is expenses. Who's going to pay for the expenses and at what point? Most attorneys will probably front the expenses, as they say. In other words,
Such as?
Pay
the
them up
doctor
front.
may require medical, to get the medical reports, a fee to get the reports. If you have to hire an expert witness, they'll want to get paid in advance. Filing fee if it has to go to court. Deposition fees if you take depositions. Subpoena fees for subpoenaing records. They can get very expensive. The last case that our office had that went to trial, I think we had 40 or